Yeah, sure. Okay. Yeah, okay. So, shall we begin? So, yeah. So this, well, maybe there's no new announcement, but let's welcome Tayfun again for his first lecture today. So, please go ahead, Tayfun. Oh, sorry.
We go on to 12:30 or
So it's still like 12, but then you said like maybe you.
let's play it by ear. I will do my best not to go until 12:30.
It's okay.
Like there is a part of this. This paper used to be two papers actually, and one is about aspects of reserve systems which might be more interested to more technical oriented people, like overlapping reserves. But the issue in India has little to do with that. That was really secondary. And those were two separate papers, but the editor insisted that that aspect is also covered. So I kind of unified the two, but I found a way so that, the whole thing is, still continuous, and I did it in sections, and sections are continuous. So we'll see if we will do the more technical part or not. It is somewhat orthogonal to the main point I will try to do today, but it's very intimately related to some of the stuff Uito and also his CS colleagues are doing to with macro theory, and so we'll see. So you can determine whether we go all the way until 12:30. So this lecture is mostly based on work with Sönmez, and it's called Affirmative Action in India via vertical, horizontal, and overlapping reservations. And the structure is a bit similar to the army branching paper. So there is a real problem. There are serious practical implications, and then there's a theory that explains what's going on. And in this lecture series, I'm also trying to place this in the context of minimalist market design, and you'll see how it will affect. Just like the Army's application, the minimalist market design will give a unique prescription for this particular problem. So in that sense, the role of the approach is basically mainly correctly identifying what is the mission of the institution, whether that's represented by some sort of an optimization problem or through axioms or whatever, and also the primitives of the problem. So once you correctly do that, just like the Army's branching problem, you also get a unique solution for this problem. Except they weren't able to find that unique solution in India for many years. So I'm unable to. Okay, sorry. Not good technology. Well, let me talk about, let me give some institutional background, and today's lecture will be very much like the Army branching part of yesterday's lecture. And in this kind of, in this approach, institutional details are extremely important, right? So 1950 Constitution of India sanctions affirmative action for government jobs, positions at public universities and legislative seats. And the way their affirmative action program is implemented is through a reserve system. Now, their problem have many different versions. In some versions, all positions are identical. Like allocation of 5,000 police positions annually at UTokyo. Okay, I will focus on that simplest problem today. Okay, and then I will talk about some extensions which are also relevant in India. For instance, in the case of allocation of university positions, the positions are heterogeneous, right? And then when you go from homogeneous goods to heterogeneous goods, like the kind of interfaces, like Ohito and his colleagues at, discrete math, computer science, those groups, like those techniques become very relevant, right? That's how I see, like the role of, M convexity, substance conditions, unilateral substitutes. To me, what they represent is, I have simple modules, I have simple methods like serial dictatorship or like priority allocation. Now you want to extend that simple methodology to more complex version of the problems, like for instance, with heterogeneity, or maybe with some diversity constraints, right? And a lot of important foundational work has been done, among many Japanese scholars in those dimensions. But I will start with the simplest version of the problem, which itself is already a very big problem in India, as you'll see. So for each of a number of disadvantaged groups, a fraction of positions are reserved, and I will be very clear about what that means. So that's how they implement their affirmative action problem. Now, they have two levels of affirmative action provisions. That's sanctioned by the Constitution. There are higher level provisions and there are lower level provisions. And I will explain what those mean. And the higher level provisions, their original beneficiaries are members of scheduled castes, scheduled tribes, other backward classes. So these are groups, which have been really, which haven't been treated well historically, and to some extent maybe even now. Okay. Recently, now, these higher level provisions were historically awarded for compensatory and reparatory purposes. So certain groups were left really behind, educationally and economically, right? So the society wants them to catch up. And so that was the original intention. Now, our last lecture will be about this last group, economically weaker section, which is based on an aspect which is transitory. It can be poor today, but rich tomorrow, right? You're not born with it, or you might born poor, but you're not stuck there. Okay? And that in itself, whether that group should be eligible for higher level provisions or not, has been itself a big debate. Obviously, I'm not in a position to say much about that, right? That's not my expertise. However, I will talk about that case and a really controversial aspect of it in tomorrow's lecture. Okay, but they also get the higher level provision. Now, importantly, these beneficiaries, like scheduled castes, scheduled tribes, other backward classes, they are distinct. They don't intersect. And person can be a member of only one of them. Normally, you would think the last one would intersect with all of these. But the court made sure that they don't intersect. And that is the issue which was causing a huge problem, actually. Okay, so basically, initially, the higher level provision, initially everybody was eligible for the higher level, only one higher level provision because of the caste system. Okay, so it was automatic. With the inclusion of the last one, it remained the same that way, but because of the court enforcement. Initially government enforcement, legislation enforcement, which is last year now also accepted by the court, and I'll argue, explain why that's a wrong decision in a very clear way. Okay. So anyways, these are higher level provisions, and everybody is eligible for only one of those privileges. Okay. The lower level provisions are not due to historical, discrimination, but rather due to other forms of disadvantage. For instance, persons with disabilities, being women, and so on and so forth. Obviously, the lower level, one can be eligible both for a higher level provision and also for a lower level provision. So unlike higher level provisions, which do not overlap, the lower level provisions do overlap with higher level provisions. And it is that particular aspect which caused lots of trouble in India. Okay. Now, the more technical part of the paper also has to do the following. In principle, the lower one can be a disabled woman. So you can have multiple lower level provisions too. Okay. And that in itself is a very interesting problem. In this lecture, I might actually make that assumption, but the paper covers actually the most general case. We'll see how much we'll be able to cover. For technically oriented, that section might be most interesting. I mean, Kenzo said yesterday, like he really likes that part of the paper, and so I think it's his most favorite part. So we'll see. Okay, so there's caste system in India. There's a lot of discrimination, right? And society is, trying to correct its implications for a more egalitarian society, right? So 1950 Constitution institutionalizes this objective in the Constitution itself, but you'll not have abstract formulas on how to do that in the Constitution. Okay, well, it turns out that was done by a very famous Supreme Court ruling. So over time, it became necessary to explain how exactly do you implement those higher level provisions and lower level provisions. Okay. So to do so, Indrasani and others versus Union of India, 1992, also known as the Mandal Commission case, after many years of, like decades of, committee work, very visible committee work, came up with this judgment. Okay, and they introduce the following two types of policies called vertical reservations and horizontal reservations. But they are saying, okay, just think about the simple version of the problem, okay, for the purpose of this lecture. Like I mentioned, there are many interesting versions. For instance, there's the dynamic version of the problem, like where positions come over time, one at a time. We are not talking about that version. We are not talking about the case where there are heterogeneous positions. I will comment about that at the conclusion only. Okay? Like all these positions are identical. Okay? If you wish, this is about the design of choice. And the means of affirmative action is reserving a fraction of seats for various groups. But what does reserve mean? Okay. One can implement reserves in many different ways. Okay. So, and justices in India were aware of this. Unlike, for instance, policymakers in Boston, where they implemented a wrong choice rule to implement their votes on crime. They intended one policy and implemented another one because they don't know that there are multiple types of reserves. So they said the following: a little clarification is in order at this juncture. All reservations are not the same nature. There are two types of reservations, which may, for the sake of convenience, be referred to as vertical reservations and horizontal reservations. Reservation in favor of scheduled castes, scheduled tribes, and other backward classes, so basically higher level provisions, which are associated with Article 16.4 of the Constitution, may be called vertical reservations, whereas reservations in favor of physically handicapped under the clause 1 of Article 6 can be referred to as horizontal reservations. Horizontal reservations cut across vertical reservations, what is called interlocking reservations. Okay. So basically, they clearly know that, so basically now they're saying, these horizontal reservations might overlap with vertical reservations. Obviously, they are aware that reserves can be implemented in multiple ways. Okay. Now, so let's talk about vertical reservations. Vertical reservations, which I'll refer to as VR protections, correspond to provisions sanctioned under Article 16.4, as I mentioned, but basically higher level provisions intended for this historically discriminated groups. And it has to be earmarked in the form of set aside. What does that mean? It means that if you actually deserve a position on your own merit, as a member of a disadvantaged group, you're not supposed to consume one of these reserved positions. You need to consume the open positions. But what that means is positions, and this you cannot do with macro. Right? So, I mean, this concept is extremely important. So justices will not say something like you first allocate open seats and then reserve seats. That's a technical procedure, right? We think like that. Computer scientists think like that. Layman doesn't think like that. They think as follows. People, like some of them don't need affirmative action to deserve the position. They would already get it. Now the question is, do you use up the privilege for those people or not? If you do, you will have less of the privilege left for other members of that group. Okay. So in the case of vertical reservations, they are saying, well, no, you shouldn't use the higher level provisions for those people who deserve it anyways. Now, the way this is stated in the court judgment is the following. In this connection, it is well to remember that the reservations under Article 16.4 do not operate like communal reservations. So what they mean is, we are not just doing, what they mean is the following. We don't do just partition groups into general category, which is basically people who are not qualified for vertical positions, vertical protections. And then you only give open to those people, and you give reserved positions to members of the VR protect. They are saying we don't do that. Why do they emphasize? Because some groups do that, right? Do partition. They pretend as if open positions are only for people who are not qualified for VR protections. They're emphasizing that is not the case. Okay, it may well happen that some members belonging to, say, scheduled caste get selected in the open competition field on the basis of their own merit. They will not be counted against the quota reserved for scheduled caste. They will be treated as open competition candidates. Okay. Now, they make a mistake here. This sentence is completely clear what is intended. But the justices, even though they are saying you shouldn't partition positions into different groups because of that, because everybody is eligible for overlapping, their brains still work in a partitioned way. And indeed, open category of positions and general category of people are used synonymously in India, even though open positions are not only intended for general category. Because of this, what they feel like they feel compelled to say, okay, you know what, this guy deserves open position, is transitioning to open category, general category, or open category, because they use synonymously. They feel compelled to think in terms of those partitions. And you see that as the problem gets more complicated, that kind of rudimentary conversion of analytical ideas into practices will start causing troubles. So I'm trying to do the following. I'm trying to give a lot more than what this is saying. I'm trying to give the sense of like these mistakes they made, why they made it. I'm trying to kind of highlight why it happened, you know. So anyways, horizontal reservations, on the other hand, they correspond to Article 16.1 for persons with disabilities, women, so on and so forth. And they are provided as minimum guarantee. So what that means is, if you allocate 100 positions, maybe women already get the number of minimum guarantee reserves, then you don't need to do anything because minimum guarantee is already satisfied. So it's not like over and above. If you want to code that into a program, you can do one of two things. You can first allocate the minimum guarantee positions to women, and then allocate all other positions to everybody else, potentially including women, but at the beginning, women would be at a disadvantage in the open positions because high score women are already gone, right? That's one thing that you can do, but that's an analytical operation. Economists do stuff like that. Computer scientists do stuff like that. Normal people don't do stuff like that. What do? They first allocate all the positions. They count, they check whether the minimum guarantee is satisfied. If it isn't, they start replacing. They include the highest score unmatched woman and remove the lowest score matchman, and so on and so forth. So that's the second rudimentary tool, the adjustment. Okay, this will also work in the simple case of the problem, no problem. But now, when you start having all of these, you have both over and above, minimum guarantee, maybe even minimum guarantees overlap with each other. And on top of that, if you wish, also put heterogeneity at different schools. You rent them. Now, you cannot manage this with rudimentary tools, right? You need our help. Well, not you, but you definitely don't need. But they do, right? So, anyways, but the principle behind horizontal reservations is they do count against HR protected position. So people don't think of choice rules. They don't think of mechanics. They think of the principle. If the person deserves on his own merit, should I be using the reserve? Well, for the case of horizontal, the answer is yes, you should. Okay. On top, there is an additional difference. Vertical reservations are meant to be hard caps. Like even if you cannot use all of them, it goes to the next year. Okay. So they are hard caps. Whereas HR protections, they are soft caps. If there aren't enough women, then men can get to this extra position. Okay, so there are two differences. Okay. So individuals can belong to at most one VR protected category in India. Initially, as I mentioned, this was because of the caste system. And since 2019, this is because of a requirement initially put by the government associated with that EWF reservation, which was last year accepted as valid by the Supreme Court. So this structure is still maintained, and I'll take that as given today, and it is the case in India. Although this will be my main topic in tomorrow's discussion, tomorrow's lecture. Now, if we don't have any horizontal reservations, implementing vertical reservations is obvious because of the fact that individuals can belong to at most one VR protected category. If they could belong to multiple, then it's less obvious. Okay, and we will talk about that version tomorrow. Okay. So what do? Well, you first allocate all the open positions, the highest merit ranking individuals. And then vertically protected positions, nobody else is eligible other than the members of that group. Obviously, they have to be allocated after open positions because of intra-Saudi. So this is like several parallel competitions, just like the open competition at the beginning, right? So let's call this choice rule over and above choice. Now, this object is a little bit different than the choice rule studied by, like economists at the beginning and also computer scientists, because it doesn't just describe who is receiving the position, a position. It's also describing who is receiving which position. And this is important because with the standard notion of choice rule, I cannot see whether intra-Saudi is satisfied or not, right? I gotta know whether the person received a protected position or open position. So what about joint implementation of vertical and horizontal reservations? So how does that work? So essentially all applications in the field in India also involve horizontal reservations. Why? Because at least for persons with disabilities, there is federally mandated horizontal reservations. Other horizontal reservations, some of them are mandated at the state level. Like women reservation is also very common and more important because of the number of positions. And it's there in about maybe half of the states, and actually some of the most important states. But at least person with disabilities one is there for everybody in the entire country. So all problems, unless you have just so few positions that you cannot really implement horizontal reservations, need to accommodate both the higher level provisions and the lower level provisions. Now, one challenge with Indira Savni is, I mean, it's a Supreme Court judgment. It's not a analytical paper. And it's kind of amazing that their statements are very vigorous, actually. We can literally formulate them, right? But they didn't think about the following. They describe what is a vertical reservation and how to implement it. They describe what's a horizontal reservation and how to check it. But they didn't think about the following. How do I implement them together? Right? So, as a result, but it's mandated in the entire country. So, all government offices, they design their own methods. Right? And because of these rudimentary techniques people are using, both at the technical level and also at the thinking level, this is not expected to go anywhere goodly at this complexity.
Just as a clarification, so when we're given this ruling, so who actually designing the rules at the state level, or
so typically what happens is the state also provides some guidelines. Sometimes the state gives the exact formula. Sometimes it gives, some principles. And if the exact formula is not given, then the specific central authority designs it.
So there are a bunch of programs.
So basically, what we refer to as a mechanism or a choice rule is not uniformly designed by a single entity. Now, sometimes even the court judgment specifies it, you'll see. Okay? Sometimes there would be documents from the government. And sometimes there are procedures by the institution. And obviously, the most important ones are court judgments, then the state guidelines, then the institutions methods. That's the hierarchy. Okay. So, but as you can imagine, you give such strong requirements for the entire country without the method. And this is a difficult problem now. I mean, it's simple if you don't do them together. But I think around 1990s, horizontal reservations started becoming a big thing. And then everybody, all institutions, all state governments, they're designing these rules. Well, they're using a rule. People are seeing that it doesn't adapt with the court with the court ruling in Rasani, and they sued. Because of that, 3 years later, Supreme Court issued another judgment. Anil Kumar Gupta versus state of Uttar Pradesh, which gave a formula to implement vertical and horizontal reservations together. Okay.
Actually, the court ruling actually this time.
So this one gave the method, but they will always give the method with example. But the examples are very clear enough. There will be, like in their case, very clear. But of course, they cannot do some of the subtleties. You can see. But then again, they've done pretty well actually. But they made one big mistake in this judgment. One very big mistake. Let me explain the method. I call this method Supreme Court of India, Anil Kumar Gupta choice. First, I'm giving a method equivalent to what they did. I will not use the language of adjustments. I will not use the language of migration. Okay. But in the paper, we are very clear about that. This is our kind of organization of this method in a way that's more compact. It's equivalent to what's actually used, but the actual description is this, and then we prove that they're equal. Okay? So no tricks. But essentially what they are doing is the following. They first derive a tentative outcome using the over and above choice. So like, first ignore the horizontal reservations. Just allocate the method, allocate the positions as if there are only higher level provisions. But that's very simple. So because of the partition structure.
So in step one, you only consider vertical.
That's right.
Okay.
That's right.
Okay.
So basically, that's what I mean by over and above choice. So basically, round one, allocate the positions as if there are only vertical reservations, and that problem is trivial. Then there are no overlapping protections. Now, in step two, you do any necessary adjustments to open category positions. Right? So that you look at open category positions. And Anil Kumar Gupta also specified the following. Okay, what does horizontal reservation mean in that rich structure? And they saw that this can be done in multiple ways. They suggested that you do it separately for each category of positions. Do it for open positions, so you will have minimum guarantees within the open positions. Then you will have minimum guarantees for the scheduled cast vertical positions, scheduled tribe vertical positions, OBC vertical positions, so on and so forth. So in a way, they simplified the problem. Okay, they call this compartmentalized horizontal reservation.
So in step two, what happens to women, for example?
So suppose we have only horizontal reservations for women, and let me go with that running example throughout much of today, actually. Okay, so at the end of step one, they do the following. They look at, in step two, the open positions. There's a minimum guarantee for women at open positions. Maybe it's already satisfied. Then they don't do anything. Yeah. Okay. But if there is a gap, then they have to do adjustment with women. But
How does it
work? Well, that's very good. Now, remember how these people are thinking. They like thinking in terms of partitions, right? And with vertical, they were also like, I described you how that kind of reflects even the language. Now, there is a problem. Suppose I'm a scheduled class woman. That's a bad example, but consider scheduled class woman. And suppose you are doing adjustment, and maybe you are missing woman both in scheduled class and in open. That woman can do an adjustment in both of them for a system, right? In principle. Why? Because now she's eligible for several different types of, arrangements. However, probably to maintain the partition simple structure, they say that people only ineligible for vertical reservations, which is called general category, can do adjustment for the open positions. Okay. Now you get back your simple partition structure again. Everything is again simple, right? First step is simple. And now adjustments is simple. Why? Because every woman is eligible for adjustment in at most one category. So that's what the red part means, and that's the root cause of the problem here, obviously. Like that will cause big problems. I mean, you can immediately see, right? Okay. So that is adjustments needed for the open positions, and then at step 3 is the same thing for any vertically protected category.
So in step 2, if there is a woman who is also disabled and not VR protected, what's going to happen in the adjustment process? In the first step, you do.
Are you talking about woman versus disabled, or are you talking about
the same person? She is a woman and disabled. What's going to happen to her in step 2?
That's unclear in their ruling.
Oh, sorry. The
So-
ruling doesn't specify.
The ruling only the ruling is best interpreted either for single horizontal reservation or non-overlapping horizontal reservation. In that case, everything they say is validified.
Okay. Yeah.
If it isn't, it's not valid.
Okay.
Okay, and that is the part Kenzo likes in the paper. So that version of the problem also has a very clean solution. The part which is most interesting for theorists. Okay, but I will mostly focus on the non-overlapping horizontal reservations because that interesting part for theorists is really, really secondary. So basically, this red part, removing vertically protected positions from considerations for horizontal reservations of the open position, open category positions, created a huge problem for 25 years. And the problem was continuing when we circulated our paper. So the problem was still valid when we circulated the paper. Okay. That issue reflects itself in 2 types of failures. The first one is no justified end. You can have a situation where a higher merit ranking individual, so basically, what's no justified enemy? A higher merit ranking individual cannot lose a position to a lower merit ranking individual unless the latter is of strictly lower privilege. I mean, if you are giving a position to a person with lower score, it better be because of affirmative action, right? And the second one is incentive. I will be a lot more precise about these corruptions. I will give the mathematical formula in the technical part. But right now, let me just give it intuitively. And it also creates an incentive compatibility issue. First discussed in IUNAMBO 2021. So basically what can happen is in India, with the exception of the new vertical reservation, which is the financial one, EWS, you are not required to claim your vertical reservation or horizontal reservation. You don't need to declare it. You are not required to declare it. You may or you may not. It's your prerogative. Okay. But now, suppose we are at the state where there is woman reservation. It's like 35%, 30%. And suppose there's maybe one vertical reservation for scheduled caste and none for their woman. As a scheduled caste woman, probably going for the open woman positions is much better for you than going for the vertical reservations, higher level provisions. So basically now you have an incentive to hide or not declare your vertical protections. Because if you declare it, you lose your lower level protections for open category. So basically, the root cause of the failure is obvious. The denial of the VR protected individuals, their open category HR protections, if they claim their VR protections. Okay, so let's see what's going on. Suppose 80% of the positions are open and 20% of the positions are reserved. Okay. And we have twice as many people as the positions. Blue is associated with general category. So these are the people who are not discriminated against. Lighter tones are associated with women. Okay. And red and pink, they are associated with the reserved category. Pink is reserved category woman. 80% of the positions are open, 20% are VR protected, which is red positions. And there's a 50% minimum guarantee in both categories of positions. How does this method work? Well, you first allocate all the open positions. And because, so in this example, what this means is, like if there's a uniformly ranked between the lowest score and the highest score. Yeah. Obviously for simplicity. So now, what do? First, you allocate open positions, and everybody will share it according to their fraction in the population given the distribution assumption. Right? Now, if you look at here, the dark colors are associated with men. And 2/3 of the positions are men. What I'll do is, I will not fill the reserve, which over and above would do. I would do the adjustment right away. Okay, so basically, I'm giving an equivalent representation of the same choice rule for illustration, to make illustration simpler, not to confuse you, basically. And also, by the way, like in the first step, or this is not the first step, actually, this is the beginning of the first step. Like the highest score people are gone all the way here. Like this is the cutoff score, if you wish. You can think of this as cutoffs, right? But what do you need to do? You need to do adjustment. So you put some of the men back. Until when? Until this empty area plus 1/3 is 1/2. So this is what? 1/6 of the entire area, right? Now, who gets these positions? Only blue woman can get it. Pink woman cannot get it. They are ineligible for these adjustments. Okay. So this picture, these scalings are precise. Okay. So all these positions go to general category woman. Now, then what do? You do the reserve positions. They feel at the same speed. Well, this is 2 steps at one actually. But it's kind of obvious that this will be 50-50. This will be the final outcome. So essentially, this example combines some steps in the most convenient way. Okay? But we have a problem, right? I mean, the disadvantaged woman have harder time getting a position than the privileged woman. This doesn't make sense, right? And certainly not what is intended. But that was the law for 25 years.
Yeah, so I perfectly understand the incentive issue here. The same picture showed, can you show the failure of no justified MP?
So no justified envy, I can immediately tell with these cutoffs, right? So all these women who are unmatched here, like all these people have justified envy. Like for instance, this woman has justified envy against this woman, which is there, right? So she has higher score. She has reserve category, but like this person is here, right? That for incentive compatibility, I need to draw another picture where this guy joins this pool, but yeah, they are conceptually related issues, right? The root cause of those 2 problems same. One is in the incentive domain, the other is in the normative domain. And the one in the normative domain, you can see in the data. The incentive one, it's harder to see from data, right? So anyways, so what happened after Anil Kumar Gupta? Now there's a method. Well, lots of people, institutions figured out that this doesn't make sense, right? So as a result, many public institutions resisted adopting this rule, and they allowed reserve category candidates to benefit from open category HR protection. Okay? And as a result, they faced litigation from general category women, even though they have low score. Right? Litigation doesn't make sense logically, but makes sense legally. So this is one case. There are thousands of cases like that. This is very large scale litigation with 120 petitions against the state of Rajasthan. I think we'll go all the way to 1230 and without the technically interesting part. So state allowed reserve category women to benefit from open category HR protections. High Court ruled that the state is at fault. So High Court is right. There are 3 levels of courts. Tribunals at the lowest level, then state high courts, then Supreme Court. And Supreme Court itself has multiple levels depending on how many judges are there in the bench. Yep. So High Court ruled that state is at fault and orders state to adopt the Supreme Court mandated procedure. Okay, so this is legally correct, but there is resistance at the state. This is another similar case at Allahabad High Court. This is very similar. 25 basically state use the method that makes sense, but they are litigated by 25 petitioners because reserve category are allowed to benefit from open category horizontal protections. But now there's a big fight. This is a polarizing case. The council, this is a very political issue in India. It's a very sensitive issue in India, like kind of similar, worse than US. The Council for Petitions argued that the error was intentional. The action of the board is not only motivated but purpose to take forward the unwritten agenda of the state government to accommodate as many number of OBC scheduled as candidates in the open category. Okay. Now, the judge of the case ruled that the state must correct their false application of HR protections, emphasizes that the state has played foul. Like basically, they're also saying it's not just mischievous, like it's not innocent, this is calculated agenda. Okay, so they made fraud. So this is a big fight. Despite that, the state appealed the judgment. Right? Because it doesn't make sense. But also lost the appeal. The High Court's decision is correct in line of the Supreme Court ruling, but you see how big the issue is. Now, this is another case at Rajasthan. Case is similar. A general category petitioner litigated against the state for allowing reserved category women to benefit from open category HR protections. So far everything is set. But unlike the earlier ones, the case is dismissed at High Court. The petitioner appeals the decision, bringing to a larger branch of the High Court, but that's also dismissed. And the justices say, this doesn't make any sense. Like they're saying the outstanding and important feature to be noticed is that it's not the case that the appellant petitioner that she obtained more marks than those 8 OBC women candidates. So they're saying, like, what are you talking about? Like, we have lower score. So, so basically, same case, different decision. Now, in other cases, a public institution used the court record. The Supreme Court mandated rule. So the rule is correct. But now you have justified envy. And the high score reserve women are litigating, saying, you know, I have a higher score. I'm the disadvantage. The lower score general category woman is receiving it. Right? So, and the judges granted the petition stating that that cannot be denied an open category position based on the reserve category members. So this decision is wrong, but makes sense, right? It's legally wrong, logically correct. So I'm kind of showing these are all consequences of the same problem, basically reflecting itself. No matter what they do, there is a problem. If you use the correct method, there is one problem. If you use the false, that makes sense, there's another problem. Now, let me give also other issues other than no justified envy. As I mentioned, you are not required to declare your vertical categories. In Bombay, High Court, several candidates withheld their reserve category memberships. Well, they didn't do that in the court, of course, but that situation went to the court. So in Bombay, several candidates withheld their reserve category membership so they could take the advantage of open category HR protection. So they figure I'm better off going for the open category horizontal positions than my vertical category positions. But the authorities requested information, maybe just use last name, to figure out what categories they belong and process the applications as if they applied for these reservations. and deny them the position. Okay, so and the petitioner lost the case, and they petitioned, but they lost it despite the faulty implementation. And not only that, it turns out that this faulty implementation has been systematic and intentional. Why? Because an order went from the government, state government, to all institutions saying, if women apply, not declaring their vertical protections, figure those vertical reservations, and allocate positions based on that. Okay. One last one. This is an example where there is a scheduled caste member who declared her scheduled caste membership. She's a woman, but there are no vertical positions for scheduled caste. So in principle, she's eligible, but she's eligible for nothing. There is no reserved position. So she lost her open category horizontal position for nothing. Right? But she appealed and hers was granted at least. So anyways, these are the number of court cases only in Supreme Court and High Court. And you can imagine how many are there in. And as there is so big issue, like this is a news, interesting, the Forest Department is recruiting on these positions post after a long gap of 26 years. The advertisement was issued in 2010 and recruitment took place in 2016 amid too many litigations over the issue of reservation. A major issue, that of women reservation, is yet to be decided by the court. With the recent observation by the High Court, the merit list will now be changed for the third time. Those already selected and present under the training might lose their jobs, blah, 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 blah. So you see, when we do not have formalism, this happens, right? But we can have these people only if we respect what they are trying to do. If we come up with our own interpretation of the problem, nobody will listen to us. Okay. Now, there is a very easy fix to this problem, right? The whole issue happened because scheduled caste woman was denied open category horizontal reservations. Just don't do that restriction. Okay. Let's call that method two-step minimum guarantee method, which is well defined if horizontal reservations are not overlapping. Okay. This method fixes all the problems, satisfies no justified envy and incentive compatibility. Very easy fix, right? And how does that work? So it started similar, okay? And then you still need to do adjustment, but you do adjustment, okay, so you empty these positions, like 1/6, but when you are filling, you make reserve woman eligible, then you allocate vertical positions. That's two-step minimum balance. Okay, so we are very excited. We sent this paper to Econometrica, and we got a very demanding revision, asking us also to deal with overlapping horizontal reservations, which incidentally we have already done another paper in a more general context. But connecting them is not very easy because the issues are somewhat unrelated. Well, I mean, they can be made related, but there's a much bigger problem already in the simple version of the problem, right? So and then COVID happens, we start working on, COVID, guidelines and vaccine allocation, so on and so forth. So I put the revision to side. Like 9 months later, I have like finally, I have some time. And then I check the laws. What's going on in India? I need to revise this paper, right? Then I realized 1 month before, the court revoked the faulty judgment exactly because of the reasons we identified and made the correction exactly the way we suggested. So that's external validity. Okay. So
They didn't the media paper.
I don't think so, because they use the notion of adjustment, whereas the notion of adjustment is in my appendix. So I think, so apparently 4 months earlier, a Gujarati High Court case, still way after we circulated the paper, and actually we even had an op-ed with Aragin Hindu, like still more than a year after we circulated. But 4 months before the Supreme Court case in Gujarat, there is a High Court case which figured out the correct method. And Supreme Court refers to them. They definitely read their case. I don't think, it's possible that a law clerk might have seen the op-ed in Hindu and like there might be some influence, but because they are using just adjustment concept, I think this is external validity, not policy impact. But I like external validity more than policy, right? Because to me, it shows the broader merit of the methodology.
Question. So your research paper is motivated by the desire to have the strategic proofness and respect of no justified envy. And
Not exact strategic proofness, but incentive compatibility.
incentive compatibility.
Because we use strategic proofness for the heterogeneous case, just to be fully, precise.
And those technical things may not be so obvious for the practical law people, right?
Well, no justified envy is. It is obvious. So when they see, it's very obvious.
That's the root of it.
So basically, they look at two people. The incentive compatibility might not be obvious, but no justified envy is obvious. It is so obvious, it is mandated by the Supreme Court ruling now.
So I'm trying to understand why you and they came up with the same mechanism. Is this mechanism kind of unique to satisfy certain properties?
Very good. Very good. Very good. It is. It is. However, there is a catch. There is a catch. When we started the project, it wasn't the reasonable solution. In the paper, we make one extra assumption and made it very clear that this is our assumption. You may or may not make it. If you also make that assumption, then the answer is unique. But you don't need to make that assumption. No justified envy is critical. You have to make it. The other one, you shouldn't. It's not necessary. But if you make it, there is a unique resolution. What is crazy is this ruling not only mandated no justified envy, they also mandated the technical assumption that we put. It is a technical assumption which can be put into words in an intuitive way. It basically means you got to do open adjustments before vertical adjustments. And the easier way to explain that is the following. The intra-SAMI issue is the following. They are saying, if you merit the open position based on your score, you don't count for vertical reservations. It's clear what this means when there are no horizontal reservations. What does it mean when there are horizontal reservations? That is ambiguous, right? Now they clarified it as follows. If you merit the open position, either because of merit or because of horizontal adjustments, you cannot be you shouldn't be given a vertical position. So it's technical what I'm saying, but also as a very intuitive explanation. So maybe I shouldn't call it the technical. But they make that interpretation now. So the missing part in intra-SAMI, this judgment clarifies. But that's not necessarily the only way to make that clarification, right? But if you make it that way, there is a unique solution, and that's the two-step minimum guarantee mechanism, right? So this judgment is just like my paper, right? They show all the issues, quote all the same cases, they mandate no justify them. As a result, they get rid of the flawed rule. They endorse this solution, two-step minimum guarantee, but it doesn't matter because maybe because of all the issues that happen, they just endorse. But actually, the axioms they enforce uniquely imply this one. And clarity is brought to implementation of VR protection in the presence of HR protections at a level that was not available before. This is what I meant. What we just discussed is number 4. Okay. So for me, this is the strongest external validity of this approach. Right? I mean, it's and this happened right. The paper was under review. So now let's do some math.
Just a little bit. So if I understand correctly, the new port document that basically is to SMG.
It endorsed.
And, yeah.
So it said, okay, no matter what you do, you gotta satisfy no justify them. They don't call it no justify them. They are giving examples.
Yeah, I looked at the question. So they probably did not specify exact.
They specify exact condition with example.
Right. And
they rescind the flawed rule because it doesn't satisfy that mandate. They also give another mandate, which then pins down everything to a unique outcome.
Yeah, actually, my question is whether they were actually they actually knew how to actually implement these actions now. Now that given that they talking about this external validity, do they actually did they also correctly find out that your mechanism is implied by the
No,
they haven't.
They don't know it's unique.
Do you know whether they can?
They don't know it's unique. That makes me more suspicious that they are just doing that by themselves.
Right now,
They're not. They're not mandating two-step minimum guarantee. They're just endorsing it. They give it. They give the formula, but I guess because of the 25 years turmoil, they don't want to give that much specifics. I guess.
But at least do you think that they actually know that
it's the unique
is at least one that satisfies all?
They know.
Okay.
They know, and they give the formula,
Okay.
but they explicitly discuss it. But they give these court rulings. They have long sections from earlier, other court rulings, and they give the entire discussion of the rule by Gujarati court.
So the use of 2SMG, was it only limited to this particular state of Upper Pradesh, or
No.
spread
So
all
what
over the
happens is
country?
the issue. But this is a ruling for the entire country.
Oh, okay.
But people sued the wrongdoing in Uttar Pradesh. But when it goes to Supreme Court, it's typical for the entire country, and this is for the entire country,
Oh, I see. Oh, I see.
right?
The defendant was the state. And,
The defendant is the state,
Yeah.
exactly,
And Supreme Court.
That's right.
Yes.
right.
For
So
the
basically,
entire country. Okay.
that's right, that's right. So let's do some math. But this, I think, we'll be able to do a lot faster. 2 is the end, everything will be exact when there are no HR protections. The stuff is more interesting when HR protections intersect. There will be interesting material stuff, but we'll not be able to do that. Already, I think I'll go all the way to 12:30 without the technically a little bit more interesting part, but you can see. And also, I'll do conceptual related stuff tomorrow. So perhaps it's not too bad. There are 2 identical positions. I is a set of individuals. Each individual is in need of 1 position, and everybody is endowed with a distinct merit score, and there are clear rules how you make it stick. There are clear tie-breaking rules in each application. So while individuals with higher merit scores have higher claims for a position in the absence of affirmative action policies, disadvantaged groups are protected through 2 types of affirmative action policies: vertical reservations, horizontal reservations. How does vertical VR policy work? It works through a system of category memberships. R is a set of reserve eligible categories. G is a category that covers everybody else. So basically, G is a category of people who are ineligible for VR protections. There is a function law which assigns each individual either to a reserve category or to nothing, which is interpreted as like, so basically, I don't want to do this to R union G because I see this as having the protected status or not. And part of the problem is because of the notation they are using, right? I want to highlight, like not only I want to solve this, I want to make it clear why they are making a mistake. Why the mistake is keeping getting bigger in more complex versions of the problem. Okay, so I also want to use the idea terminology. Okay, so basically, the row specifies your category. If row is C, it means you belong to VR protected category C. If it is equal to empty set, then you belong to general category. So QC positions are exclusively set aside for members of category C. We are protected category C. It's exclusive, hard reserves. If you subtract, if you subtract all these vertical reserve positions from all positions, now we get the number of open category positions. Okay, so unlike India, I will differentiate between category of positions and category of individuals. I will not use, I will only use general category for people and open category for positions. And that is one big mistake they are making, using it synonymous. And that's initiated at the courts. I mean, it's very natural, but like for laymen, it's just, this stuff is just too analytically complex for people who are not formally trained to deal with, to be honest, right? Okay, so calligraphic B is the vertical categories for all positions, including the open position. Okay. And IV is the set of people who are eligible for category V. If V happens to be open category, then this is everybody. If V happens to be a reserved category, this is only members of that category. Okay, now to deal with this problem, I need to use with a different solution concept than the one that's used in the literature. Given a category V, this could be open, this could be reserved, a single category choice rule is a function which assigns a set of positions from any set of applicants in such a way that you only assign positions to people who are eligible, and you don't you satisfy the capacity. Okay, so this is our standard choice rule notion that we use, but that I will call single category choice rule. What I refer as a choice rule is a multi-category version of the same thing, one for each category, in such a way that, first of all, for each category, that part is kind of like a single category choice rule, and nobody is assigned a position from two different categories. You either get one or the other one. Okay. Now, I will also talk about the notion of aggregate choice rule, which is the counterpart of choice rule in the traditional literature. So this is people who just receive positions. Some of my results will be just given in terms of the aggregate choice rule. Okay. What about horizontal reservations? HR policies manage through a system of trait ownerships, which I will denote by calligraphic T. And there is a function tau, which assigns each agent a subset of traits. Given any category V and trait T, QVT is the minimum number of category V positions that must be guaranteed to eligible individuals with trait T in a soft reserve basis, meaning if you don't have enough people with that trait, you can give it to other people, provided that they're eligible for the category. Okay. So these positions I will call category V HR protected positions for trait T. Now, while each individual is a member of a single category, which is either a reserve category or general category, she may have multiple traits. I will refer to HR policies where an individual can have at most one trait as non-overlapping HR protections. The most obvious case would be just one trait, obviously. And HR policies where an individual can have multiple traits as overlapping HR protections. It turns out that both versions of the problem has a very clean solution, although the latter one is more complex. As far as the procedure is concerned, but I'm not complex to you, but to justices it will be complex. So I will mostly restrict attention to the case of non-overlapping HR protections, because the possibility of overlaps is never discussed in those judgments, actually. So basically, not only this case is considerably simpler, the court rulings are presented for this case, and their own faulty rule is not even well defined for this more general case, because now, you know, how you exactly process HR protections, in what sequence or together, like that will actually, like their flawed rule have multiple interpretations in the case of overlaps. And the failure is already very prominent in the absence of that complication. Okay. And moreover, the policy implications of our paper is much sharper in this case. I cannot claim uniqueness. I can now say the following. For as long as they don't have overlapping HR protections, if they're not using my rule, you can sue them. Like I can find people whenever the outcome is different than the rule or the outcome of my rule, I can locate people and sue them, and provide that the court works right, we will win. Like in the entire country. I cannot claim that completely. It will likely happen in the overlapping case, but there are some, maybe I'll make a few comments why that is important and why it is an easy solution, depending on. Okay. HR protections are provided within each vertical category on a minimum guarantee basis. This means that positions obtained without invoking any HR protection still accommodate the HR protections. Observe that. I'm always describing things, principles, in a way that can be read by the justices, lawyers. I'm not saying things like first allocate this, then allocate that, and expect justices or lawyers to make a mathematical observation. Given any category V, HR protections can be implemented with minimum guarantee choice rule, originally introduced by Ekenike and Yennas, 2015. So what do? You first, for each trade, you first allocate open positions to highest, not open. You, for each trade D, this is just with one category. Okay. So forget multiple categories for a second. Suppose there's only category B positions and there's a bunch of individuals eligible for category B positions. Then what do? Well, in India, they do adjustments. But what do we do to code this as simple as possible? You first fill minimum guarantees, horizontal reservations, because trades do not overlap. This gives a unique outcome. Maybe you fill all trade positions, maybe you don't. If you don't, they'll go to the rest of the positions anyways, because these are soft reserves. But in the step 2, you allocate all non-trade positions, so non-horizontally protected positions, category B positions, plus maybe the leftover trade positions based on merit, right? So that's minimum guarantee choice. What is 2-step minimum guarantee choice rule? Well, you first do this for open category to eligible individuals. And in step 2, you do it for the leftover people who are eligible for each vertical category. And because none of the vertical categories overlap, this is also uniquely defined. Very simple. Life is so simple. So, as I mentioned, Saurav Yadav marks the end of an era where a 3-judge bench of the Supreme Court brought an end to the 25-year tenure of the flawed rulings. Yes.
I'm very slow. Could you explain again? Yeah, step 1, step 2. So step 1.
Step 1. So is there confusion about the superscript or so basically this is my multi.
It's in step 1, the step 2, V doesn't appear. So what happens to
so V is O or C?
Oh, I see.
right? So basically, I first like V is R union O,
Okay, okay.
right? I first do this for O,
And then you
and then I do for each R. It's category R, focusing on people who are not chosen and who are eligible for category C.
Oh, I see.
Right? Very clear, right? So we already discussed these points, right? What happened with Saurawiya Dao, and we mentioned that no justified envy is mandated, but they just endorsed two-step minimum guarantee rule. But essentially, through their other mandates, they enforced, even though they likely don't realize, they don't know. But there is no other rule which satisfies.
So what's the proper? Two SMG must have good properties, right? So it respects no justified
I will now.
incentive.
Yep, I will give them now.
Oh, okay.
I will give them now, and they will be all conditions mandated by law. Right? They are not conditions I'm making up. Well, I'm making up, but I'm putting what justices are writing into mathematical formula, mathematical representation. So, accurately identifying the root cause of the crisis as the failure of no justified envy under the flawed choice rule, the justices have mandated that important axiom under Saurawiya Dao. On top of no justified envy, 3 additional desiderata are also mandated, either already by Indrasani or with this new one. So now I will formulate all 4 rigorously, but for this simple case of non-overlap. Actually, you know what? I think the way I will unify this, this formulation is also valid in the more general case, but you see, I'll do a trick which allows me to cover both cases with the same terminology. I will say that a choice rule is non-wasteful if no matter which group of individuals I take, which category I pick, and which individual in that set if it is the case that this guy is not given any position at any category, remember, C-hat is the aggregate choice rule, right? This guy is unmatched. And there is a vacant spot, unused spot at category V. It has to be the case that this J guy is not eligible for category. Yeah? So that's non-wastefulness. You can only leave a position empty, idle, if there is no unmatched person who is eligible for that position. You can leave it idle, like all the scheduled cast people are gone, and you can have it needs to go to the next year.
Okay. But if you are more ambitious, and if in the end in category B, if you have empty seats, you would like to fill this. No. Suppose you would like to do that. Can you design a mechanism to satisfy stronger version of non-wastefulness condition?
So I can, but so I can make the hard reserves soft reserves. Okay, but then I will lose. I know.
Sorry.
Right? The uniqueness.
Just change it.
Sure.
Soft reserve.
Sure. Just do a soft reserve.
Okay, good.
So that's trivial. Okay. Right? But this is not something I will suggest because that is a sensitive issue. Right? But of course, it's a perfectly valid technocratic objective. but not one. So in line with minimalist market design.
No, they don't care because that kind of thing,
It's
not
rare.
It's
So
extremely rare.
it's not relevant, that's correct, but yeah, like occasionally it becomes relevant in small cases, not in major cases, but like, I mean, they use this method, even like you allocate 10 positions for gardener, you know, like in a hospital, they use the same formula. In cases like that, it could happen. Like it's a village, but even then you cannot use. But yeah, practically this is not an issue. That's the first action. I will give an auxiliary concept which allows me to describe all other axioms in a simpler way, and also in a way that relates to the more complex version of the problem. Okay? Given a vertical category V, HR maximality function NV simply gives the following. Given the number of people that are eligible for those positions, okay, so like these are applicants. They're all eligible for category V. What is the number of horizontal reservations I can honor at most? Now, in India, all positions are announced as category trait pairs, which means even if you have two of them, like disabled woman, you'll either consume the woman position or the trait position. You'll not accommodate both of them just because the way the positions are allocated, right? That I call, so basically the implementation already implies that each person accommodates only one horizontal trait. This is irrelevant anyways if horizontal traits do not overlap, but it is relevant, you know, when they do overlap, okay? So suppose horizontal positions do not overlap, then what is that maximum number? Well, I look at the set of people. I look at the number of people who has a given trait T. I check whether that number is higher than number of trait T positions or lower than it. If it is higher than it, then I can accommodate all trait T positions. If it is lower, I can only accommodate whoever has trait. I add those numbers, given that there is no overlap. So this is the maximum number I can honor, right? Now, this is a more complex problem in the case of overlap, because now I have to figure out which trait disabled woman accommodates. And what we do is, we do this in an endogenous way. Depending on who is there. Like it gives me flexibility, right? If the next person in line is woman, then I use the disabled trait. If it is disabled, then I use, I mean, I'll not talk about that, but that's the simple way to generalize this idea. And for that, I can also use the same NV. That's why I can use the same formula using that NV function. If I was just looking at the simple case, I wouldn't need to define this NV function, right? Anyways, so basically, this is the maximum number of horizontal protected positions I can honor feasibly at category V. So now, back to axioms. A choice rule C maximally accommodate horizontal protections if for every set of individuals, for every category, And for every individual who is eligible for category V, but remains unmatched. If I were to add this guy to category V, I couldn't possibly increase the number of horizontal reserve V category V positions that are honored. So basically, like when there are women who are unmatched, you shouldn't be having idle women positions. That's what this is saying. And that's for every single category. But with categories other than a full category, there's extra requirement that the woman you are considering needs to be eligible for that category, right? So basically, very simple condition, right? And obviously, this is what's intended by horizontal reservations. Like the woman would go to court if this is not satisfied. So what is choice rule? What is no justified envy? Like I give the informal description, intuitive description. A choice rule C satisfies no justified envy if for every set of individuals, for every category V, for every individual I who is received a category V position, and for every person J who was eligible for that category V position, which I got, but remained unmatched. Okay, now there's a tension between I and J. Well, J doesn't like the situation. It better be the case that either I received it because of her higher merit score, or because if you instead give it to J rather than I, you will be honoring strictly fewer horizontal reservations. So either because of merit or because of affirmative action, right? So also, now in India, if you interpret this principle for open category, if V is equal to open, this principle is called principle of merit in judgments. There's a name. If it is for other categories, reserve categories, it's called principle of inter se merit. Okay, last axiom. Now, this is axiom, is the generalization of this over and above, like this idea that you cannot use vertical protected position for people who can receive the position with their own merit anyways. This is the generalization of that idea for the case there are also horizontal reservations, and in the way that is generalized in Saravya. Okay? A choice rule C complies with VR protections if for each set of individuals I, reserve eligible category C, whenever you give individual I a reserved position at category C, thereby not giving him an open position, the following three conditions must hold. When can you give somebody reserved position and not the open position? First of all, there shouldn't be any open position left. Second of all, if you look at people who receive open positions, they either have higher score or they were increasing the utilization of horizontal reservations. So basically, everybody who received the open positions, instead of this guy, either received it because of higher merit or because of affirmative action for horizontal reservation, for lower level provision, horizontal level provision. Now, these two was always intended. And they make complete sense with this over and above idea. Before Saurav Yadav, when I was writing the paper, what was unclear is, suppose I'm a schedule, there is a scheduled cast woman. And she can, and you couldn't fill either open woman positions or scheduled cast open positions. Scheduled cast woman positions. And normally I should be able to, you give her either position, right? Why necessarily give the open, why use her for open category adjustment? But when they say, when they rephrase the intra-Sauni mandate by saying, people who are meritorious of the open positions are those who either deserve it due to merit score or due to horizontal adjustment, then they are also including this third condition, which means this person who received category C position and thereby not the open position shouldn't be able to increase the utilization of open category horizontal reservations. Why? Because otherwise she would deserve open category position, not because of the score, but because of increasing the utilization of horizontal reservations for open category.
Unfortunately, I got lost here. So the first condition say that you already allocated all open positions, right?
Yes.
So how come can you still get the third case in which you add I to the?
Well, I mean, these are all full, but maybe it doesn't have enough women. Right? So remember, this is an O function. This is what is the NO function? The number of horizontal reservations that can be honored. So if you fill all positions, but if 2 fails, what it means is you gave a scheduled cast woman a scheduled cast position, maybe because of horizontal adjustment, or maybe because of just standard vertical position, doesn't matter, when you could have used that woman to increase the number of women positions at open category. And they mandated that. But it wasn't obvious before Saurav Yadav. So when I still introduced this condition for my characterization. After all, I'm not just solving their problem. I'm also trying to write an interesting paper where theorists also like what I'm doing, right? So I say, okay, look, I can give multiple methods. I actually gave in the first version, but referees, it's too complicated. Just give us the simple one. So given that I'm giving the simple one, let me also give a characterization for the simple one, which is a simple interpretation, but it wasn't the law. But then it's it became the law. That is the part I find like completely crazy. Like, I'm not surprised that, I'm surprised, of course, they found the correct, no justified enemy axiom, correct all this stuff. But to me, what is really, really surprising is they also clarified this over and above condition in such a way that my extra condition is also mandated. So that's very interesting. Well, maybe not that interesting because it has a simple interpretation. Remember, Indrasamy is saying if you deserve it based on merit, open position, you shouldn't be given reserved position. But that's causing problem when there are horizontal reservations. So they need to explain what it means getting it based on merit. Right. One natural one is getting it merit includes through horizontal reservations too. It's horizontal merit. Is there any? So this one, I gave, like in the appendix, you can see, exactly how this is suggested. Like there is no, nothing I'm inventing here. Everything is in this code ruling. Everything is exact. For the case of non-overlapping horizontal reservations. For the case of overlapping horizontal reservations, I have to invent stuff because their method is not well defined. But that version of the problem too has a perfectly clean solution. Okay. So, and basically, this is the Indrasamy statement, what it means vertical reservation. But this blue part was not rigorous for when there are horizontal reservations. Now it is rigorous. It's our. Okay. So basically, this weakness is cleared if you merit it either with invoking, either without invoking horizontal reservations, horizontal protections, or with invoking horizontal reservations. I mean, the open position. Do you merit? Do you deserve it or not? You are allowed to use your horizontal privileges in this definition. That's what the law is saying. Okay. And with that clarification, the four mandates uniquely imply two-state minimum guarantee mechanism. You can intuitively feel that, right? Because adjustment first needs to go for the open, right? That simplifies the solution quite a lot. So literally in India, if they do not use the method that is endorsed and not enforced, in every case where the outcome differs from the outcome of this method, there's a potential lawsuit that can be won, that should be won if the court doesn't make mistake. In every single case, I think there are lots of potential interesting empirical exercises here. So basically, even though they didn't enforce it through the method, they did enforce it through other mandates of the judgment. Okay. So I will skip this overlapping HR protections given the time, but I think I already gave enough intuition. Like basically, we'll basically do smart reserves for horizontal reservation. Like we will decide whether you get the woman one or a disabled one. There'll be a functional, quiz there. And if you do that, I mean, you might look at the slides. There's a very clean solution for the one category case. It's a very novel choice rule for the case of like this, the counterpart of minimum guarantee, but with smart reserves. You do not mechanically first fill woman or first fill disabled. You fill all of them together. And it depends on who else is there. You figure out that, okay, this disabled woman will be matched. I just do not know which reserve, which trade we'll be using. It will depend, it will be determined at the very end. And it basically says that when you do that, the outcome of this procedure, Gale dominates any other method that's legal. Gale dominates mean the highest score person match has at least as high score. The second one has at least as high score, and so on. So that's what Gale domination means. Okay. And two-step version of that is exactly the same idea, except instead of minimum guarantee at each step, now we use meritorious horizontal, smart reserve for trends. Okay, and I'll do related stuff tomorrow for vertical reserve. So you'll see a little bit of that. And basically, in the more general case, you have exactly the same characterization. Right? Exactly the same uniqueness. Why is that not implied by the law? It's not implied by the law because of the following ambiguity. I can basically mechanically order all the traits and use minimum guarantee in each one. Not doing the smart version. That's legal. Right? So my axioms, I'm trying to maximize HR, like I'm trying to maximize the number of horizontal reservations I can accommodate, right? So suppose there is only one disabled person. There is one disabled position, one woman position. Okay. Now suppose one person is eligible for both of them. And there is also another woman. My method doesn't allow giving the woman position to disabled woman so that the other position goes is not utilized for horizontal reservations. All right. But now this is a mathematical operation which requires optimization. You cannot go to court and say, like in the easier case, you are just saying it is because of that person I'm compromised. Whereas in this case, you'll need to say, you know what? You gave the wrong reserve to that person, give it the other one, and then I can give this one. Right? So it's reasonable. I'm not saying it's not reasonable. But people in the field will not be able to find that. It requires more information and such. Right? So I'm not saying that this result, I mean, this is, I love this result. But I cannot claim that. This is implied by the law. That's what I'm saying. Whereas for the non-overlapping case, I can say. Anyways, how much difference that makes compared to just naive minimum guarantee, I don't know. Interesting empirical question. But the issue will be much less important than the main issue. Okay, so basically over the years, Indian justices have done a fantastic job of formulating various desiderata for reservation policies, but designing mechanisms to implement these desiderata often requires additional expertise. So this is where collaboration with market designers can provide very concrete benefits to the society, right? The failure of the AKG SCI choice rule is on the tip of the iceberg. In India, the problem is a more complex version of the problem, where positions are heterogeneous across multiple institutions. Sometimes in the case of college admissions, but sometimes in the case of some prestigious positions. And they use the same rudimentary, techniques to extend these methods. And not only the rules for those cases have similar failures, their judgments have inconsistencies between themselves. It's just basically too much for them. Now, based on we have another paper with Sönmez. And in that paper, what we do is the following. We say that, okay, give me the axioms for the basic case. The court cases discussed only for homogeneous case. But intrasound was for all cases. And made the clarification. I think it's reasonably interpreted that clarification is intended more general for all ambiguities in the original case. That doesn't give me a unique method. However, if you either give me Pareto principle or strategic proofness, then the choice rule that we have given, together with deferred acceptance, for the most general version of the problem, overlapping horizontal reservations, multiple institutions, now we have these results. First of all mechanisms that satisfies Indrasawny or Saurayada, the choice rule we introduced, the complex one, for the most general case, if you use together with deferred acceptance, that Pareto dominates any other legal method. Okay? Or forget Pareto principle. These are the law. Well, individual rationality is not given, but I think it's implicit, obviously. Extra, just give me strategic purpose. That's not in the law. Right? But give me that. Then there's a unique method which satisfies. But thank you very much. I really pushed the limit of everything. I mean, it's hopefully this was kind of fun. Thank you very much.